Welcome to the Animal Law Podcast. This is Marianne Sullivan, and today we will be talking about cows, chickens, pigs, securities law, the SEC, and the Amazon rainforest, and actually some very, very high stakes. I will be chatting with Laura Fox of the Farmed Animal Advocacy Clinic at Vermont Law and Graduate School, and Stijn van Osch of the Humane Society of the United States about a complaint that was recently filed with the Securities and Exchange Commission about the efforts of agribusiness megagiant JBS to go public in the U.S. and how they are attempting to comply with the very, very inconvenient requirements of the SEC that they tell the truth to investors. There's a lot to unpack here, and I have to say, even as someone who knows next to nothing about securities law, I found this to be not only quite understandable, but incredibly compelling and important. On another note, before we get to that interview, I'd just love you to listen to this very quick chat I had with attorney Ankita Shankar, who is heading up a worldwide effort to coordinate an international animal law moot court. This is seriously an amazing project. I was so impressed. There are all these law schools and professors from every corner of the world who are coming together to create this platform in which up-and-coming lawyers from everywhere can learn about what's happening to animals and what the law, especially international law, which is another subject I know nothing about, can play in their lives. Ankita Shankar earned her postgraduate degree in law from Oxford University and qualified as a barrister at the Bar of England and Wales. She has specialized in public international law, animal law, and legal philosophy and theory, and is currently working towards her doctorate in animal rights legal philosophy and theory at the universities of Basel and Helsinki. And here she is. Welcome to the Animal Law Podcast, Ankita.
Hi, thank you.
Did I say your name right? I didn't ask you before we started, which I really should have.
Yes, you did.
It seems kind of obvious, but you never know. I'm so excited to be talking to you. I really want to hear more about this whole project, which is very exciting. I thought maybe we'd start. You can give us maybe a brief overview of what this World Moot is, and then I'll ask some follow-up questions and make it clear how people can participate if they want to.
Perfect. Yes. Absolutely. So the World Moot is a nonprofit organization, and our mission is to train future generations of lawyers in effective animal rights advocacy. We do this through two components. So on the one hand, we have a World Moot Court competition. So that's basically an international advocacy competition that students across the world can participate in. They do so first by participating in their region, and then the winners from those regions participate on the international stage. And the second component comprises two sets of training courses. So the first training course set is aimed at law teachers who want to improve their legal skills training by learning how to coach moots better. And the other set is aimed at students who want to enhance their moot skills, so their legal advocacy skill in the context of moot court competitions. Both these components are focused on animal rights. So in the case of the moot court competition, we deal with issues of public international law, such as international human rights law and international environmental law. So these are traditional aspects and how they interact with contemporary aspects of animal rights, which is the theme that runs through the entire moot problem. And for the training courses, we deal with general skills training, but using examples from animal rights litigation, especially within the specific regions in which we hold the training. The overall idea is that we provide a space where students and teachers and experts in the field can come into contact and exchange ideas. And one of the most important aspects of this is to promote a unified rather than fragmented development of animal rights law, because what I have seen through my career so far is that brilliant arguments are being made in courts all over the world, but there isn't enough dialogue and debate between practitioners in different countries. So we've got these innovative arguments that are made for animal rights. In Northern America, we see a lot of arguments that animals have personhood and should be granted habeas corpus as a writ. In Latin America, we see a strong focus on environmental rights and animal rights. It's part of the environment and part of the rights of nature.
Yeah.
In Southern Asia, we see a huge focus on animals having inherent rights based on their inherent value, with judgments sometimes drawing on philosophical literature, and so on and so forth. So in different parts of the world, there are different strategies that are adopted, different arguments that are made. And what we want to do is encourage this cross-pollination of ideas. So when our participants argue these cases, they are encouraged to look at these judgments holistically. They're encouraged to draw on the different viewpoints and to bring them all together, to tie them together and present the arguments before panels of experienced animal rights academics and practitioners and public international law academics and practitioners.
Such a powerful idea. And I can't tell you how important I think this is. I think it's so true that, when I teach animal law, I do try to reference some of the things that have happened in Latin America and India in particular, but it's very hard for me to do that. I mean, there's a language barrier, obviously, but even when things have been translated, law is such a specifically jurisdictional thing. Here in the States, it's hard to move from one state to another and practice law. I mean, people are very, very wedded to their jurisdiction. So it's very difficult to access and understand all of these different ideas. But as with everything with animals, I just think that the community of people who care about animals, who care deeply about animals, is everywhere. I like to say we are a nation unto ourselves. I feel more community with people on the other side of the world who get it about animals than I do with the people who live next door to me sometimes. So this just brings those concepts together and tries to do something about addressing them. So all right, I will start going on and just talk a little bit more about practical matters. I mean, this is a big undertaking. You're covering the entire world. So you've divided the world into regions, correct? And in those regions, there are participating schools. Can you just kind of tell us about the roles of those two concepts?
Yes, absolutely. So we don't actually have premises in all of the regions. And what we do is we partner with universities. So in each region, we have a number of host universities who take turns hosting the events where our moot competition and our moot training courses can be brought to life. Each region is actually managed by 2 regional co-directors. Most regions have 2. And they are responsible for ensuring the success of their region, which kind of functions under the overall umbrella of the VMLAR. At the international level, we have an international committee made up of departments who oversee the overall functioning and provide direction and guidance, deal with things like marketing and IT and legal affairs. We're currently a team 22 strong and growing. And if you see the profiles of the various people we have, they're all specialists and experts in their field. So we bring with us a wide array of expertise, of specialism, of knowledge, of skills, and we put everything together in order to hopefully produce what is an extraordinary series of events that will be the next step in bridging together this world to unite animal advocates in all corners of the world and developing the field of animal rights law.
And I was very excited to see in your list of participants, both the judges and many names I recognized and many names I didn't recognize. That's always a really nice combination. So yeah, lots of people getting involved in this. So even each of these regions still covers many countries and a very wide geographic area. How do students who are in, I particularly would love to reach students who might be interested in participating. How would they participate? Give us the details. If somebody is listening to this and says, I want to do this, I would love to do this. Do they have to have a team as they do in so many moot court competitions, or can they join as individuals? And it's still a very wide geographic area. Do they have to participate in person in the arguments, or can it be done on Zoom or some other way of participating remotely? Is everybody all over the world going to be working on the exact same case? And just go into a little bit of the details for somebody out there who says, yeah, maybe I want to do this.
So the first thing that I want to highlight is we wanted to make this competition and these training courses as accessible as possible. We, of course, don't have the resources or the time to hold these components in every country that we wanted to reach. So we are offering both the course and the competition in an in-person format or in an online format. So participants can choose how they would like to participate. We are also looking into securing scholarships so we can waive fees and make it easier for participants and sort of needs and merit-based scholarships so that we are accessible to everybody everywhere who wants to learn more about animal law and mooting. If somebody who is watching this wants to participate, so first I would warmly welcome you and encourage you to join and to participate in the VMLAR, because we are doing something groundbreaking, something new and exciting, which we feel has a tremendous amount of potential to shape your career as an animal advocate. The first thing to do is to go onto our website and sign up. So registrations are currently open for 3 regions, and as the year progresses, we will open them for more. Actually, let's take one step back. I think the first step to do would be to sign up to our newsletter so you can stay informed about our developments, our events, etc. And then it is to fill out this registration application form. And after that, what happens is the applications are analyzed, they are accepted or rejected depending on, whether all the requirements are met. Once an application is complete and has been accepted, it's forwarded on to the host university, who is actually the organizer of the event. The host university sends out the payment details, participants make payment, and they receive the moot documents. Or in the case of training courses, of course, they don't receive the moot documents, but for the competition, they do. And after that, they have time to prepare. The deadlines are published on the website. They are mentioned in the registration form. They have time to prepare and then participate in whichever component they choose to participate in.
I'm sorry, do you mean by that either the competition or the training courses?
Yes.
Okay. So you can either do just the training course or the competition, or do you expect people to do the training course in order to prepare themselves to do the competition?
No. So the idea was, and of course, everyone is welcome to participate in either or both, but the idea was that we have the training courses for those students who might need to enhance their mooting skills before participating in the competition, and the competition for those who feel confident enough in their mooting skills to participate in the competition.
Okay. And you said that registrations are open for 3 of the regions, but I assume people can find out the dates, which are not too far in the distant future, when registrations will be open all over the world, right?
Right. So we open it region by region because the competitions and the training courses are held at different times in different regions. So we open it sort of X amount of time before the events actually take place. We keep them open for a limited amount of time, and the moot problem is released only upon confirmation of registration and participation, because we want to ensure that even though the events are held at different times throughout the year, no team gets an unfair advantage by getting, say, 6 months with the moot problem as opposed to 1 month.
Right. Wow, this is a very complicated undertaking. I have to say, I admire you for just thinking it all up and then making it happen. So everybody is working on the same problem, and there will be ultimately an international competition of finalists, right?
Absolutely.
When and where is the first competition? Is it here in the States?
The first region to open is Southern Asia.
For some reason, I did think that the one here was first, but I guess I was wrong. All right. So the first one will be in Southern Asia.
That's right. Yeah. And it'll be in India. They will be hosting Eastern and Southeastern Asia as well. Perhaps you might have thought it would start in the United States, because when we did our regional groupings, region 1 is actually the United States of America.
Maybe that was why, yeah.
That's not the order. Yeah. The order of events is not the same as the order that we have listed our regions in.
Is everybody participating in English?
Yes.
Okay. And tell me more about the finals. It's a huge undertaking. You have many steps before you get there, but what is the end result?
Well, the end result would be 8 teams that would participate, compete against each other to get an overall winning team. Currently, we haven't finalized the date or the location of the finals, but it is most likely to be 15th February in London, 2025. Yeah, but the details are still being confirmed, so I can't guarantee that that is what it'll be.
One thing I did ask you, which I'm not sure you addressed, if you did, I apologize, but let me go back. Say a student is here listening and they want to participate, not in the training, but in the moot court. Do they have to have a team? Do they have to set up their team themselves? And is that a 2-person team?
Oh, sorry, yes, I didn't actually answer that. So for the competition, it can be between 2 and 4 participants. You need at least 2. The registrations are actually done on behalf of the university, so you would need to be part of a law school in order to register, and the university would be doing the registration. So a university representative would be doing the registration for the team. And for the training course, it's also a university representative who does it, but the training course can be anywhere from 1 to 4 participants.
Okay. And that's a very standard thing that law schools do, help their students register for various moot court competitions, right? This isn't like any different than a standard one. It's just a new one. It's very exciting. And can you give me an idea of how much, you said there were some scholarships available, but how much will it cost for students to participate? I mean, obviously, if they're going to travel in order to do it, they would have to undertake that, or their university would have to undertake that kind of cost. But what if they weren't going to travel?
So the registration fee actually differs region by region, depending on what the costs are for hosting in that particular region, right? So we don't see a cent of the registration fee. The way we structure it, even the host wouldn't see a cent of the registration fee, because everything we raise, we would put right back into the events. But that said, it differs very widely. So the first region that we opened registrations in, I believe it was something like, the online courses were much cheaper and the online competition was much cheaper, but in person it would have been around $250 US.
US dollars, yeah.
Yeah.
Okay. I mean, I imagine most people who are listening, for the same problem we were talking about in the beginning, most people who listen to this podcast, which is a law podcast, are from the States because, that's the applicable law. So I imagine most people who are listening would be interested in the North American competition. We don't have that many international listeners for this podcast. But I hope those who are listening, I hope some are excited about it. I just think it's incredibly exciting. And one of the reasons is because, and I assume this is the thing that is driving you really feel that international law, which is something most people hardly study in law school. I mean, I suppose there are some people who specialize, but certainly here, people are a little bit more concerned with, the thing they're going to confront every day in a more local practice. But it's a really important part of changing the status and treatment of animals, isn't it?
Yes, 100%. And the skills that our participants will gain, we expect that they will be relevant not only on the international stage, but also at the domestic level, because for example, learning about arguments that are commonly made in other parts of the world helps strengthen the arguments that you would make before your own courts. And international law, I feel, would be one of the more powerful tools to achieving this at a global level, because animal abuse, animal exploitation, it's a global problem. It's not only global, but it's also a globalized problem. And so solutions need to be found at a wider scale than merely at the domestic level, because we see also that animal protection laws vary greatly from country to country. And it's entirely possible that issues of animal exploitation that might not exist in a particular country could exist in countries where animal products are, for example, being imported from. So this is actually quite an intricate issue, but if we think about it, it would make, for instance, animal products could be more cheaply produced in a country that doesn't have animal welfare standards at all, and then exported to countries that have very high animal welfare standards. They would be available more cheaply on the market. So we have a number of issues that we face, and even countries with very stringent laws don't necessarily have barriers that prevent, for example, products of animal exploitation or products of animal abuse coming into their countries. But more importantly, animals are everywhere. They suffer everywhere. And we need a solution that works not only for some animals in some parts of the world, but all animals in all parts of the world. And just like it was the case with human rights, we cannot guarantee that every single country is going to rise to that level of protection. So we need an international body of law that regulates it. We need countries to make each other better, countries to learn from each other, countries to hold each other to higher standards, which the hope is will keep getting higher and higher until we reach a point where animal exploitation itself would be a thing of the past.
Very inspiring. And you're absolutely right. I mean, of course, animals are the subject of commerce and trade. And of course, that always gets exported to, whether here in the States, whether it's a state issue or whether it's internationally, it gets exported to the least common denominator, the place with the low. Of course it does, because that's the cheapest and it's all about the money. So this is such incredibly important work. I'm very excited about it. And thank you so much for joining us to share. I really hope a lot of students who are listening will get involved.
Thank you very much. It's been a pleasure speaking with you and bringing the Vermlar and our vision and mission to as many people as we possibly can. We look forward to increased participation. We look forward to making this event as large as we can accommodate.
Your work has really been incredible to date, and I'm sure it's going to be an amazing event. And that's WMILAR.com?
Yes.
Excellent. All right, everybody who's listening, go sign up. I hope many of you will be interested in looking into participating in the moot court or the training courses. I truly think it sounds extraordinary. What an effort. But now let's get to the main interview. This is a long episode today. I hope you're ready. Laura Fox is a visiting professor and the inaugural director of the Farmed Animal Advocacy Clinic at Vermont Law and Graduate School. Before joining the law school, Professor Fox was a senior staff attorney at the Humane Society of the United States, focusing on farmed animal protection in HSUS's Animal Protection Law Department. Stijn van Osch is a Michigan attorney who currently works at the Humane Society of the United States as part of its animal protection law team. At HSUS, he focuses on farm animal welfare issues such as sow housing, cage-free eggs, and organic farm welfare standards. Prior to joining HSUS in 2022, he was counsel in Latham Watkins DC office, where he specialized in environmental and chemical regulatory law. Welcome to the Animal Law Podcast, Laura. Actually, welcome back, Laura, and welcome to you, Stijn.
Thank you.
Thanks for having us.
Animal law leads you into all sorts of different places. And I know nothing about securities law, and I imagine a lot of the listeners don't know a lot about it either. So you're going to have to spell it out. But I just think there's a lot of exciting things going on with this whole approach that allows you to do things that perhaps you couldn't do through litigation. But let's start with some preliminary questions about what's going on here. What is JBS? I imagine most of our listeners kind of know what JBS is, but actually it's a little bit more broad. You would refer to the group, which is a larger entity than JBS itself.
Yeah, it's a lot more complicated than just JBS. When you hear JBS, I think you're generally referring to JBS SA, which is a Brazilian corporation. But just like many mega corporations, there's a lot of corporate shielding, restructuring, different subsidies, other sub-corporations. And so we have a lot of that going on here. So we have JBS SA, which is what you would traditionally think of when you say JBS.
And they are the largest meat company in the world, right? I mean, they're big. Even just JBS SA.
Yeah, maybe after I lay out the corporate structure, we can go into the numbers, because the numbers are just so mind-blowingly huge.
Yeah.
And we'll just use the numbers that they themselves put forward in their SEC filings. But yeah, so we have the Dutch affiliation in the Netherlands, JBS BV. We have JBS US Foods, which is pretty easy, it's US. And they're all going to be kind of restructuring into this global corporate entity called JBS NV. And so that's sort of the global JBS that's seeking this public offering. And then you want to keep in mind some of its subsidiaries. And the major one at play here is Pilgrim's Pride, which I'm sure a lot of U.S. audience members are familiar with as the second largest poultry producer in the world. So we have some really huge, major corporations under the JBS umbrella. And so to go to how giant they are. So they're the number one global beef producer in terms of capacity. This is over 75,000 head of cattle on the daily being able to be processed by these corporations. 13.7 million chickens daily, 142,000 hogs on the daily. And then you wouldn't necessarily know that they're also a fish producer, and they claim to have a daily processing capacity of over 200 tons of fish. So these are daily numbers. It's hard to wrap your mind around how many animals are being produced by these companies. And then to square that with the idea that they're somehow operating sustainably is pretty mind-boggling.
So before we get to that, and it is pretty mind-boggling, and actually that description was mind-boggling for me. I mean, before I read your papers, I didn't even know that Pilgrim's Pride was a JBS. I suppose I should have known that, but I didn't. So what they basically want to do is bring these companies together. Is that right? And also, just as a very preliminary question, just to set the scene, can you just tell us what, and I've never heard of this before, of course, because I know nothing about securities law, an F4 registration statement and preliminary prospectus? Because that's something that we're dealing with here. And so I think that we should start off by introducing our listeners who probably have never heard of that before, what that is.
You're correct. JBS is looking to go public. That's what they're doing. That's sort of the common phrase used for it. And what that means is that they want to sell shares to investors on a stock exchange, specifically the New York Stock Exchange in the US. They are already public in Brazil, but not in the US. Pilgrim's Pride is a public corporation. You can buy stock in Pilgrim's Pride, but it's only a subsidiary of JBS. So what JBS wants to do, it wants to take its current complicated corporate structure and basically consolidate everything underneath one Dutch firm, JBS, BV, NV, depending, the NV is the public entity eventually. That will happen. It hasn't happened yet. But as part of this restructuring, they will have one big parent corporation in the Netherlands. And underneath that, you will have the Brazilian, the US, the Chinese, and all the other operations that they have. That company is filing the Form F4. That is basically the formal step you need to take to go public and be approved to sell shares on a United States stock exchange.
Okay.
In this case, the New York one. You file these papers with the SEC, the Securities and Exchange Commission, and they have to approve your selling shares to the public. As part of the process, they look at the entire, what they call the registration statement, in which a company, like in this case JBS, lays out its business. It tells investors of the risk of investing in that business. They have to show the numbers, the financials, the corporate structure, have to explain what they're doing, all those kinds of things. And there's also some information that's filed, specific with the SEC that is a separate part. It's very technical. We don't have to get into it. But basically, the SEC looks at all the information and then has to make sure that this company is not a sham, that this company is not saying anything that's untrue to investors, those kinds of things. So the SEC is there to protect the American investors, and by extension, the American public, from frauds, from misleading companies. And that's why you have to go through this process. So JBS can't sell shares yet, but has taken all the steps it needs to get there.
These questions are probably stupid, but all right. So they want to consolidate all of these JBS companies into a Dutch company, but we're talking about the American regulated New York Stock Exchange. Are they selling shares in their company elsewhere in the world, or is this a preliminary step in order to be able to go public anywhere?
They are selling shares already. So some of the pieces of JBS, shall we say, are already publicly traded. Pilgrim's Pride is publicly traded in the United States.
Okay.
JBS, the Brazilian company, JBS SA, is publicly traded in Brazil.
But what about JBS NV? Are they reliant on the SEC in order to sell shares anywhere, or is this just regulating what's happening in the US?
Yeah, so JBS NV will be this newly traded entity on the New York Stock Exchange. So until this moves forward, it's been given effectiveness by the SEC JBS NV will not be listing shares on the New York Stock Exchange. American investors can still acquire shares in JBS, but they do so what's called over the counter, right? So JBS SA is listed in Sao Paulo Stock Exchange, on the Frankfurt Stock Exchange, I think Hong Kong, not entirely sure, but I think so. But anyway,
we don't need to know that.
US investors can still broker deals and buy on those exchanges over the counter. So technically, all those security exchanges that have impacts on the US and US investors are within the purview of the SEC already and the Securities Exchange Act. But with registering with the SEC and listing shares on the New York exchange market, there's additional filings that you would have to do with the SEC, additional affirmative disclosures that companies need to go through. So those are going to be like the newly imposed SEC provisions on JBS NV once their IPO is effective.
Okay. I know I kind of went down a side road there, but since I know so little about this, I can't help but do that. I think that you covered, my next question was going to be, who are the animals that are involved? But you kind of covered that. It's like just gazillions and gazillions of animals. These companies are huge. All right. So since we're talking about securities law, and I imagine most of our listeners, like me, aren't that familiar, can you just kind of lay out the basics on what is required vis-a-vis truth-telling when you're filing papers pursuant to U.S. federal securities laws? I mean, I assume you could just say you're supposed to tell the truth, but I imagine there's more detail to it than that.
There is. So when it comes to these IPOs, there are various different separate legal rules that apply. There is a general rule, the most commonly referred to as Rule 10b-5, right? I'd have to look.
Yeah, 10b-5.
I think it's Rule 10b-5. Yes, thank you. That generally prohibits public companies from making misleading statements to investors. There is a lot of nuance to that rule and how it applies, but that applies to any publicly traded company. The gist of it is they cannot make statements that are misleading or make statements that omit something that is misleading investors. With the qualification, it has to be material. So anything that investors would consider important in making an investment decision is sort of the letter of the law. So that's sort of a general rule. There is also a set of specific things that a company has to disclose. A big one there is called Regulation SK, under which there are a variety of items which are in the registration statement that a company has to affirmatively tell investors. A lot of them have to do with what the company is, what the company does, and risks involved and downsides in investing. So a company can't hide, for example, that it has, $1 billion lawsuit pending against it, because if they lose $1 billion, that would be very important. So there's a lot of things. So they have to spell out lawsuits. They have to spell out regulatory risks, enforcement, things like that. And the SEC has to go through the registration statement and make sure that these things are disclosed. And of course, a company can't omit anything that is material that it's required to disclose under these regulations, or again, make a disclosure of one of these things that is misleading, untruthful, not complete, any of those kinds of things. So there is a lot that a company has to disclose, qualified with this quote unquote materiality standard, which makes it a little fuzzy. On the one hand, a company has to disclose certain things in the Form F4 and a registration statement, and anything else they say, whether in the registration statement, on a website, in a sustainability report, anything else they say to investors cannot be misleading under Rule 10b-5, under that general rule of misleading investors. So both of those are at play. They often intersect, right? Because if you say, well, we may have a risk of, enforcement over this issue, that can be both a violation of Regulation SK, because if you say you may have a risk, but there's already a lawsuit pending, for example, you're not fully disclosing, and you're also misleading investors under Rule 10b-5. So there's a lot of overlap between the two.
Right. Yeah, that would make sense. Yeah.
The big difference, and that's the last thing I'll say about it, because you can dive into this forever.
I'm sure we could get into unending amounts of weeds, but I think you're doing a great job of giving us the amount of weeds we need.
Yeah. The biggest difference is that the affirmative disclosure requirements, like in Regulation SK, are generally only enforceable by the SEC itself. There is some complications, but the big enforcer there is the SEC. It's much more difficult to enforce those privately. Rule 10b-5, you can enforce privately. And Rule 10b-5, as I said, applies to statements, any statements made by the company to investors or to the public that investors can see. Whereas the disclosure requirements tend to be very specific, like it has to be in a Form F4, or if you're already a public company, in your annual reports or 10Ks. So like there's like specific forms and formats in which those disclosure regulations apply. Rule 10b-5, basically anything the company says.
All right. That's really, really helpful. And I mean, I just want to say for anybody listening, like me, when I first started reading this, it dawned on me that there are just unbelievable opportunities here for animal lawyers who have such a difficult time doing anything against these large companies because of standing issues. But here, I mean, there are complaints that you can make. And I think that's really interesting that actually for the 10b-5 things, you're saying that there is some sort of public enforcement, which let's get into that later. But even just the opportunity to ask these questions is so unusual for animal lawyers to have anybody look at these questions. And we'll get into the issue of whether the SEC is going to look at them and how much that's actually going to happen and how much we can make that happen. But still, even without that, there's such interesting opportunities here for animal lawyers. Before we get to the factual allegations, which, you know, obviously, I promised everybody I'm going to get to them at some point. It always takes a long time before you get to the actual substance. I'd just like to point to this one general statement that you made that I thought was very telling. Quote, importantly, the duty to disclose requires adequate disclosure of known risks that have already materialized by the time of the IPO, which of course is just in case, the IPO is the offering. I think most people probably know that, but initial public offering, that's the actual offering, that have already materialized by the time of the IPO. And these may not be framed as hypotheticals. As a general matter, and we'll get into the specifics later, do you think this is a lot of what JBS has been doing here, pretending kind of to live in the past, that things might happen that actually are already happening?
Yeah, I absolutely think that is true. And that seems to be a kind of tactic that is used a lot throughout their F1 disclosures. I think that specifically relates to, and this, I'm sure we'll develop this more when we talk about the actual allegations, but laws that are currently in effect that will be made to account to JBS in the near future over climate disclosures, over their deforestation practices. And so because those laws are already passed and there's a date of effectiveness that is known, these are risks that the company should know whether or not they're going to face and how they're going to deal with them. And so those types of analyses should be made very clear in the type of filing that we're talking about.
Yeah, everything that you pointed out here. Did you want to add something, Stijn?
I was going to say, generally, companies don't like to disclose bad things. And a lot of these disclosures, if you read a lot of annual reports and Form F4s, a lot of them are framed as like, well, this may happen, this might happen, even though in many cases, risks like regulations, climate change impacts are occurring and really aren't hypothetical anymore. But it is almost standard practice to frame anything that you can as a may or might so as to not scare off investors.
Yeah. Events are definitely overtaking them, particularly when it comes to climate, of course. All right. And we're not going to focus just on climate because really your number one issue, the issue you put first, of course, is the animal welfare issue, which is, makes sense since that's the area that you have the expertise in. So the factual allegations are divided and dealing with the animal welfare issue. We all know, I mean, this seems like a kind of global question, that animal welfare is important. I mean, we all have devoted our lives to thinking that animal welfare actually matters, but it's not as obvious that it matters to investors. And that's what we're talking about here. So what is your general argument about why, assuming they're telling lies about animal welfare, and we all know that, obviously they are, because otherwise they'd be out of business, why should the SEC believe that this is something investors need to know, as opposed to, animal activists?
Yeah, that's a great question, right? So one of the threshold questions is are these representations material to investor decisions? So what we've spelled out in our letter to the SEC is that investor groups and individual investors see animal welfare and a company's treatment of animal as material to the financial solvency of that company. We see large investment groups making those statements, and we see reputational damage coming to companies who are exposed for inhumane treatment or making misrepresentations about animal welfare. And so ultimately, investors know that how you're treating an animal will impact your bottom line. And so therefore is material to investors in those companies.
Yeah, there is research to back this up. So the investors, they're not wrong. There is some really good research, if people are interested and want to look into this further, done by FAIR, FAIRR, the FAIR Initiative.
Who really, they were they might have been the leaders in this whole movement.
They have done a lot in the animal and investment space. Yeah. And they have some great, very detailed reports that I definitely cannot recite by heart, but I've seen them, that sort of explain how companies with poor animal welfare records, how that impacts their financial bottom line. For example, if there are investigations or scandals about animal mistreatment, you lose consumer confidence, you lose sales, right? That's just one example. Yeah. So part of this piece of the puzzle is just the loss of reputation and consumer confidence, which impacts the business. And, that's one of the reasons why it's material. It's because if you treat your animals poorly, people will know and people will stop buying your stuff.
Yeah, I think it's good to take a moment to congratulate this whole movement that has made that argument even possible, even though sometimes we'd think, why don't consumers pay more attention? But, let's take a step back and realize that it's a ticking time bomb for them, the way they treat animals and when these reports come out. And it's all due to the work of activists in this movement. And so I just want to take a moment to recognize that. And another thing I guess I got from your papers that I thought was interesting was that it's not just the risk that consumers will find out and start buying the products. It's the risk that other investors will notice that some consumers are not buying. Investors will start seeing the risk, and that creates a much bigger risk. It kind of multiplies the risk. If investors start noticing that this is a risk, then you've got a huge risk because they start pulling out as well. It's an exponential thing.
Yeah, it all builds on each other. But the ultimate effect is animal welfare. I think at this point, there's really good arguments and pretty well established that it impacts companies, especially a company like, a company that sells meat from farmed animals, that it will impact their business and their bottom line, and that therefore it's material and should be part of these disclosures.
There was something in your argument about morality, which is nice to see in an SEC. I like the word morality. But if there were, I know this isn't the case, but if there were no business risks, can you still argue that violations of fundamental morality are material? I guess they would never be able to say there's no business risk because you could always say, well, if people find out, I don't know. But I'm just wondering where the balance is between between how much an argument that this is immoral actually matters.
Yeah, it depends on which commissioner at the SEC you ask.
Oh, God.
So the standard for materiality is if it at all influences your investment decisions. So that, in a nutshell, could be just a moral claims about how we treat our animals does impact my investment decision as an investor. And so if you're making misleading false statements about something that I find to care about, that I want to invest in, that should be sufficient to check that material box, because I can say that this has influenced my investment decisions. However, the conservatives in the commission are starting to read into the materiality standard. Financial materiality is how they would define the term, which has never been the standard, but that's how they want to start reading the standard. And so when you are positioning an argument before the SEC, you want to make sure that not only are you alleging that things are influencing investor behavior, but they're gonna have a financial impact on the business. And so that's when you say, you know, not only are these rooted in moral concerns, but they also relate to a company's reputation and financial performance.
Yeah.
I thought that question was beside the point, but now I'm really glad I asked it, because that's a really interesting kind of split in the way they're thinking about it. And it is a little hard to separate it. Like, if something's really, really immoral, isn't there a chance it's going to affect your bottom line, that people will notice that at some point? It's really difficult to draw that line. Did you want to add something, Stijn?
Yeah, the meaning of materiality is a long-standing issue of sort of dispute, you know, courts. Very often it ends up being some kind of business materiality under the US laws. I will note, in Europe, you're starting to see the development of disclosure standards that are more based on, you know, companies have to disclose information just because people think it is important information, even if it may not have a huge business impact, like, you know, business climate impact. Like, it's one of those things that we're also fighting over in the US right now. Climate, pollution, externalities, costs that are imposed on the environment for companies are typically a positive thing because they don't pay for the pollution. So they typically don't have to disclose how much they pollute because they don't pay for it. And the more they pollute, the more money they can make. So actually, it's a good thing. And in Europe now we see, and we have the US climate rule, and we may touch on that later. And in Europe, there's now rules that go into effect in a few years that talk about companies having to disclose their impacts on the environment, regardless of whether or not that has a negative business impact, but just because people think it's important to know these things. Yeah. So it's certainly, this is an ongoing sort of philosophical trend in securities law and regulating companies. Is what should they disclose, and why are we requiring them to disclose it? Is it because it's important to the business, or just because we think it is important that companies disclose these things? And the US and the EU are a little bit diverging on this, but hopefully the trend is towards more disclosure on climate and environmental issues. So,
yeah, well, I'm glad that the trend is in that way, because that's like an amazingly cynical point. The more you can offload your costs, your externalities, not only is it better for you because you don't have to pay for them, but then it ends up being better for you because you don't have to disclose them. So that's insane.
It's, you know, you could say, look, we expanded our production. We have even more cattle out there burping out methane and farting out methane, but we don't care about that, because the fact that we have more cows is only a good thing. So we're not going to talk about the methane, because that's not our concern. Our concern, what we're telling investors, is look at all the cows that we have and all the money we're making off of these cows. So that's the traditional, classical, more conservative sort of way of thinking about these things. And with the new climate rule that the SEC put out in Europe, thinking about these things is starting to change. So hopefully that continues.
All right, let's get to I mean, I know they're very intertwined, the climate and the animal welfare issue, but let's talk about what it is that they're claiming and what it is that's true and what you see as the material differences between those things. Can you just kind of summarize that? I mean, you know, taking into account that our listeners know a lot about what happens to animals and they don't have to hear about it in excruciating detail, but so really focusing on what do they claim?
Yeah, so there's kind of three buckets of information that they're claiming that we, the Humane Society and the Center for Biological Diversity, allege are deceptive or misleading. So the first relates to animal welfare misrepresentations, and the next climate misrepresentations, and then the next deforestation practice misrepresentations. So should we start with animal welfare?
Yeah, let's start with animal welfare, yeah.
Okay, so here are some of the claims that JBS makes related to its animal welfare. They, quote, are committed to meeting or exceeding government and industry standards for humane animal handling. They expect all their animals to be handled in a safe and humane manner throughout their supply chain. And they're committed to providing livestock and poultry under its care with comfortable and safe housing that meet those animals' needs. Wow. So why do we think those are misleading? Well, let's start with one of the lower.
Because we live in reality.
one of the lower hanging fruits was this idea that they meet or exceed government humane handling standards, when all you have to do is go over to USDA Food Safety Inspection Services website and look up the litany of humane methods of handling and Poultry Product Production Act violations at their slaughter facilities. And so that's one of the things that's outlined in the complaint. They don't at all meet those very minimal standards of humane
Seriously,
handling.
if that's the standard, it's a pretty sad one, but apparently and it only applies to slaughter, but apparently they don't even meet that. So you've got USDA evidence on your side.
Yeah, a rare time where USDA actions come favorably on our side.
So if they were, let's say they were as good as everybody else. I mean, what you're saying is that they're actually worse than other meat companies. I mean, all of those statements would be untrue of any meat company in the United States, like the comfortable housing or whatever it was. Do they have to be worse than everybody else, or is it just like what they're saying is just not true, even if the rest of them are bad too?
Right, exactly. So they're going to be judged on what representations they make and whether or not they are fully truthful, or whether they are just half-truths, or there's some omitted material information that would create a fuller picture for those that are reading these statements. Another thing that we outlined related to their animal welfare claims is, so they make these claims about providing care and comfortable and safe housing, but then paradoxically, they claim that those types of things, whether an animal is in pain or experiencing distress, is difficult to achieve, if not impossible to measure. And so on the one hand, they claim, they're committed to providing comfortable and safe care to the animals. But on the other hand, they claim the animal's comfort and safety is impossible to measure. And so how could it be both true?
Unbelievable, yeah.
So just those alone make it misleading.
Similarly to the other thing, I mean, it's just like they're living in the past. Back in the 90s, the industry used to be able to get away with this totally behaviorist kind of talk about animal welfare. Like, who knows what they're experiencing? We're well past that. I mean, there's lots of people who know. And all you have to do is look, and then too. So it seems like a lot of what they're doing is trying to return to the really abysmal days before anybody was paying attention to this at all. And, that train has left the station. And you point out too, they've actually gone backwards on disclosures regarding animal welfare. That their disclosures used to say with more clarity, was it? And now they're trying to fudge more things?
Not really more clarity, I would say, but they did have one sentence in one of, I think maybe their original F4. So an F4 is filed, the SEC staff will submit comments. This happens kind of behind the scenes. And then based on the comments that the company gets from the SEC, amendments will be filed. So like a new F4. So they've done now 3 iterations of their F4, and they've taken out a disclosure of that there is a trend of consumers' preference to higher welfare products, and that they risk potential financial, reputational, negative impacts to that consumer demand. They acknowledge that that's a risk originally, but now they have scrubbed that from their disclosures.
That's kind of, I know you guys are embedded in this, but that's kind of hilarious. Like the thing they changed was whether consumers have expectations.
It is kind of strange.
As if that could have changed in the simple.
Yeah, it's right. That's our point. There is nothing that would have changed in how consumers look at these things between, when was it, like September or last year and March of this year.
Not changes like we've instituted these reforms in the way we treat our animals. Just like, no, consumers actually don't expect that. We were wrong. I'm sorry, I interrupted you, Laura. Do you want to finish your thought?
Yeah, I was just going to say, so now when you look at what type of disclosures are made related to the treatment of animals, the care of animals, animal welfare, there are only 3 references to welfare in the 1,000-page disclosure filing. And those predominantly are related to compliance with animal welfare standards or having higher welfare containers or something like that. But there is such a gap in any representations about their animal welfare practices and what risks those pose to investors and to consumers.
I think that is one of those examples of the sort of more traditional thinking and those externalities. Treating your animals poorly, unless there is a big scandal around it. But in general, like just treating your animals poorly just makes you more money as a farming company.
Right.
And so the traditional thinking is, as long as we make more money, why would we need to disclose these kinds of things? It's not business, and so then you get into the question of, is it something they have to disclose under these risk factors? We argue it definitely is. Animal welfare nowadays especially is something that people care about, and you should disclose your risks fully. But it's another example of the past way of thinking about pure business risks and does this impact my bottom line, which cruel confinement doesn't impact your bottom line. In fact, it was done because it makes companies more profitable. But now we're in a different era. One thing I would add is that it also shows you the difference in standards. So you got the disclosures in the F4 on one side, and they barely talk about animal welfare there. And then you have all their great statements about animal welfare that Laura mentioned that they put on their website and in their sustainability report and sort of to the public. And your Rule 10b-5 does apply to those, right? They can't be misleading people, even if they're not talking about animal welfare in that F4 at all. So there's a bit of that contrast. And here's what we have to disclose under the rules on the one hand, virtually nothing about animal welfare. Here's what we want to tell people publicly. And we're going to spin this whole great tale about how we're meeting or exceeding standards.
Yeah, and if they didn't think it was important to consumers, why would they be saying it?
Exactly. Why would you put that out there prominently on your website and in your sustainability report? But the moment that they become a public company, they fall under the Rule 10b-5, and arguably they already do because they already sell some of those foreign shares, right?
Right.
But especially if they do an IPO, everything they're saying falls under Rule 10b-5 in SEC jurisdictions. So the moment that they do this IPO, they will be misleading the public about their animal welfare just based on that. So there's a little call back to what we talked about earlier, the differences in the rules and these trends here.
And one thing I also wanted to go back to before we pass it, you talked about the USDA reports showing the truth about their record on slaughter, but you also, obviously the USDA doesn't look at what happens to animals on the farm because we don't have any laws protecting animals on the farm. So you were also able to use the whole history of undercover work that's been done by the movement, including HSUS's, groundbreaking work in this area. And I just want to take a moment to revisit the fact that this movement sometimes feels like it's not accomplishing anything. And when you see it all put together here in order to make arguments years later, it really makes people feel good that maybe we have gotten somewhere. I always like to think one day it's just all going to change, on a dime.
I hope you're right.
This huge body of evidence that we have built up is going to dawn on people that this matters. All right, I'll stop. I'll stop my my hopefulness because it's ridiculous. I also wanted to visit another thing because did we talk about Scienter? I don't think we did. And it isn't required for all your claims, but it is required for some. And so I'm just curious, what is it required for? Is it the 10b-5 requirements? And what do you have to prove, and how do you prove it? Do you just have to prove that they knew what they were doing to these animals? Or do you have to prove that they lied about it? Or do you have to prove that they knew it created risk? And how do you prove that? No, I said that question in a complicated way, but I'm just wondering how much of a problem is Scienter here?
The Scienter standard's pretty low. It can be met on circumstantial evidence, and you just have to show that the company knew facts or had access to information that suggested that their representations were not accurate. Or, almost like a negligent standard that they failed to check information or monitor information such that they were negligent in knowing facts they should have known. So we spell out in the complaint how the knowledge aspects met, but it's fairly a low bar.
Oh, that's really good news because, these are their companies. Presumably they knew what they were doing in them. That doesn't seem like that hard to prove.
Right. That's, again, one of those things where if you're doing it, so 10b-5 is often enforced in private litigation. And it depends on the judge you pick and how, not you pick, the judge you get, judge that's picked for you, on how strictly they interpret scienter. We're complaining to the SEC, and the SEC has broad enforcement powers and has a whole bunch of other things that they can look at. So it's a little easier if the SEC chooses to take action to just say these companies should have known. And in the case of things they have to disclose, like under Regulation SK, there isn't even a scienter requirement. They just need to disclose what they're required to disclose. So the context here, the forum, the fact that we're complaining to the SEC and the SEC would hopefully take enforcement action also makes it easier for them to act than a private litigant would.
All right. So, yeah, and I want to get into your choices about private versus SEC enforcement. But first, those are my questions about the animal welfare allegations. If you want to add anything, please do. But I'd also like to talk about, obviously, the climate disclosures and lack of disclosures. Was there anything you wanted to add about animal welfare that I didn't cover?
Not specifically about JBS, but in the broader context of securities and animal welfare, HSUS, this is all part of of course, HSUS's broader strategy to use the law in any which way we can to advance animal welfare, in this case, farm animal welfare. This is not HSUS's first SEC complaint. There have been many in the past, some of Laura's, and shareholder actions, things like that. So this is definitely an area that can be fertile ground for action. HSUS and others are working in this space and using securities law to try and get these issues on the agenda before agencies out in the public. And so I just wanted to note that.
Yeah, this isn't a one-off.
This isn't a one-off. This is part of a broader effort.
Good to know. So it's about time I got caught up to speed on it. All right, so let's talk about their net zero claims, what they're claiming, what you're arguing.
Yeah. So regarding what they represented over now years-long campaign is that they are committed to achieve net zero. So that's on balance, emitting no greenhouse gases by 2040.
Can I just stop you for a second? Because net zero, I feel, has been one of those terms that's gotten fudged in some circumstances. And are they claiming net zero at that point or emitting no greenhouse gases? Because the whole question of our offsets has kind of been used to, I think, muddy the waters there. Or is it not entirely clear what they're claiming?
Right. So, I mean, the representation is net zero, and they're on the hook for all reasonable interpretations of what that representation is. So unless they clearly defined it, which I don't think that they have, that's net zero. That's, in our minds, emitting no greenhouse gases. And then they, go further and make statements that it's not only our operations, but our supply chain. So they're kind of taking on a broader scope of emissions when they're claiming net zero.
Wow, they're really out there on a limb, aren't they?
There is an offset piece. So my understanding is their plan is underdefined. But from what I understand, there's two pieces. They said we're going to reduce emissions by a certain percentage, and the rest we're going to offset. So there is an offset element to it, as far as I understand from what I've read in what they have said, which of course offsets are
nonsense.
Are mostly nonsense. But it is impossible, as you mentioned, to get rid of all the emissions.
Yeah, I mean, we know that, but have they done anything? Are they headed on any kind of a positive track, or is this all just nonsense?
Oh, have at it, Laura.
Yeah, it's hard to know that claim. So even if they make sort of disclosures later or in other places about whether or not they're going to meet this through offsets, they've made a bold representation on their website that just said net zero by 2040, right? And you're not responsible to go digging around. So they were challenged before the Better Business Bureau with the National Advertising Division over these claims. The Better Business Bureau and its appeal board found that these were misleading statements. And now they're being sued by the Attorney General's office in New York over these claims.
Right. Yeah, I really wanted to pick out how, because a lot of us have heard of that litigation, and I was wondering how it related to your arguments here.
Yeah. And then, to look at their latest amendment to their F4, they're claiming that they're in the process of setting science-based targets in their effort to reduce carbon emissions across their shared value chain. I would expect that before I had made my net zero commitment, I would have done the analysis to know whether this was achievable. But now they're in the process doing science-based targets through the Science-Based Target Initiative, so they claim. But to what extent they've done anything,
Well, what does that even mean? They're in the process. I'm in the process of making $1 million because I made 20 last week. What the hell does that mean? We're in the process. I mean, it could mean something, but there's certainly no way to know.
No one knows. And that's part of the reason why the Better Business Bureau found that their claims were misleading. It's because they do not have any concrete, achievable, clear plans to get to net zero 2040. And that's also what the New York Attorney General is now claiming.
Okay, and we'll leave that up to her. I really wanted to focus on the animal welfare claims because that's what we're all about. But this is also obviously hugely important. And there are two really specific, I know you put these in different categories, but two really specific statutes that you're pointing out that they're not dealing with how they're going to comply with these statutes. Can you tell us what that is? Because that seems really easy to pin down. I mean, if there are statutes that require them to do something and they're not doing it, that doesn't seem like a difficult argument to make, is it?
Yes, the first one just directly related to what we're talking about. It's California's Voluntary Carbon Market Disclosures Act. And so that means that by January 2025, any company that makes a net zero claim, makes a claim about reducing emissions, anything kind of related to their climate impacts, they're going to have to publish on their website the ways in which they've evaluated that claim, and they're going to achieve that claim. While that's passed, there's a clear deadline to meet it, and yet nowhere in the registration statement is this mentioned. And it's unclear in the process of doing the science-based evaluation of this net zero claim, are they on track to be able to publish that math on the website by January 2025? They should know this already. So this sort of goes back to if they're known risks, you can't just posit these in hypotheticals, or you don't know at this point. And that needs to be made clear to investors.
Well, good for California. God, that just seems like you just have to give us some evidence for these claims. What a radical law.
Yeah, California is at the forefront of many of these things nowadays. Yeah. If they don't have anything, they just have to say, we don't have any math. In which case, somebody like the New York Attorney General can say, see?
Yeah.
They don't have anything. So it's really the minimum you would expect from companies.
Seriously, it's like not even an onerous requirement. It's just tell us why you think what you're saying is true.
Yes, exactly.
And just to complete the circle, there's this European Union deforestation regulation, which they also haven't disclosed how they're going to deal with that. Is that right?
That's right. Yes. So there is a regulation in the EU that will prohibit, it's passed, it's on the books, will prohibit the import of products. It's a specified list of products. One of them is beef. Others are like soy, cocoa, palm oil, those kinds of things, without a certificate that it's deforestation free, basically, is the gist of it. Deforestation has been a major, major issue in beef production in Brazil, which for the most part is JBS, for decades. They clear-cut Amazon rainforest to grow feed for animals and for land to grow the animals for ranches. They clear cut, they burn in patches. It, destroys the Amazon, destroys wildlife habitat. It's all around. It's terrible practice. And there's been increasing pressure from consumers, from advocates, and now from governments responding to that pressure to eliminate deforestation in the supply chain of these kinds of products, including beef. JBS has claimed that it is addressing deforestation, that it has reduced deforestation. But if you look into it, it is still happening left and right. And JBS is just looking the other way when their suppliers are cutting down another acre of rainforest here and there. But they're going to have to comply and with third-party certification show that the beef they're selling to the EU and other products. But we'll take beef as the big example.
Right.
That is deforestation free. And it seems very unlikely that they will be able to do that given their practices. And they only disclose this risk at a very high level. They're sort of saying, well, this law exists. We may have to do some work to comply with it. It might impact our business. They know by now what the deforestation is like in their supply chain and how much they've done about it, which, according to all the external evidence that we know of, is not much. So they should be disclosing that risk much more clearly to investors, because it could lead, the penalties for this law are huge. You could be banned from selling in the EU.
Yeah, that's pretty huge. Aside from that, even, I think, as you were talking about it, it's occurred to me that I think deforestation of the Amazon, and we're talking about a Brazilian company here, so obviously, that is like one of the few things that has really reached public consciousness as a huge problem. So it could go, like they actually have to, because of this law, disclose more about what's going on there. I mean, it goes beyond the EU. I mean, that's the kind of thing that, people like to think it's because of tofu, but let's face it, if there's one thing that people know about, it's that the Amazon is disappearing and are nervous about. So I think the implications of that could be even bigger than getting banned from selling in the EU, which would be fairly big.
I think so. Yes, that's, again, the business impact is sales, right? But of course, it's going to have a way bigger, softer impact on reputation.
And that will have a business impact as well.
Exactly. So all of these things are reasons why they should just be very clearly disclosing how they're planning to comply with this law, which they're not. They're just saying, we'll see.
All right. I think if there's anything else about the complaint itself that you want to add, but I would like to talk also about potential relief and what happens next. So what is the relief here?
Before we move on, I guess one thing that kind of keeps me scratching my head is they make either no claims in regards to how it's going to comply with California's new law. They make very broad hypothetical statements about what's going to happen with EU. But what they're not hypothetical about and unclear about is their bullish plans of expansion, that they will be increasing production over the next 4 or 5 years by, 6% or so, right? Which we talked about the numbers. That's huge. That's huge. So to square emissions reduction and deforestation-free production with expanded production, it's hard to understand how they're going to match their investors' expectations on increasing production and also meet their commitments to eliminate emissions and source deforestation-free beef.
But it really is crazy. Like, this is about investors, and they're promising they're going to grow by 6%, and they have absolutely no explanation about how they could possibly do that without further destroying the planet. It really is the whole thing is kind of crazy. It does make you feel like sometimes when it's like the oil industry, you just feel like they're all trying to get the last bit they can out of this planet before things go down. And I don't know where they're going with their billions after the planet goes down, but they obviously have some kind of plan. But it really feels like the oil industry, like, let's just really try to squeeze the last bit we can out of this industry. Anyway, it kind of brings up the question, do they have any obligation to talk about the development of alternative meats as potential competition? To us, it seems like a huge big deal. To us, it seems like you're going to be replaced people. Do they have any obligation to mention that to their investors?
They do. And they do.
Okay.
In the sense that they disclose. They do talk about, in a hypothetical general way, as these things are typically done, but they do mention that changes in consumer preference and the rise of meat alternatives could impact the market for meat and could impact their bottom line because people shift, demand shifts.
Okay.
Interesting side note, JBS has also acquired plant-based meat companies.
Right.
And I believe a lab meat company too. So they are very well aware of this shift and are moving in that space themselves too, which raises a lot of questions of corporate consolidation of the food industry. But suffice to say that that is a trend that JBS is aware of, that can impact their business, that they do talk about at a high level in their F4 and that they're part of.
Yeah. Well, I mean, you certainly want them to be part of it in the sense that that.
Yeah, well, you don't want them to also grow by 6% all their animal meat output, but
I would rather see nice people make the money, but I'd rather see all the animals.
Exactly. Like if they would announce we're getting rid of all of our livestock and instead we're only making plant-based meat, that would be a great announcement, but I don't think.
I'd be so on board. All right. So if that's it for the substance, can we move on to like, what kind of relief do you get? What happens next? I mean, you filed it's called a complaint, right? And you file this complaint. I assume they respond. What's the process here?
No. Oh, man. SEC complaints kind of go into a black box or hole.
I was afraid that was going to be the answer.
Yeah. So unlike, if we file a similar complaint with another agency, a lot of times they'll bring us in and ask questions. They'll bring a company in and they'll let us know that they're doing this. SEC kind of takes the complaint and then we don't really know what's going on with it so much. But it doesn't mean they don't do anything with it.
Do they have an obligation to do anything? Or is it totally up to them?
I mean, it's discretionary, right? It's a request for kind of enforcement and investigation, right? So that's discretionary upon what the agency decides to do with its resources. But right now we're in a posture where there's lots of scrutiny over this IPO. We're not the only ones that have filed a complaint with the SEC. We have U.S. senators who have sent a letter. We have UK Parliament that got involved, other organizations like Rainforest Alliance Network and Mighty Earth, right? There's lots of scrutiny over this IPO, and it's bipartisan. The latest letter was sent by, I think, a representative out of Wyoming. And a lot of it has to do with previous bribery scandals and how this is bad for the U.S. market and all that, which, yes, endorse. But this complaint that the Humane Society and CBD submitted really wanted to focus on the misrepresentations in the animal welfare climate and deforestation space. Yeah. And the request that we're seeking is just the SEC take a closer look at the filings and deny what would be issued is a notice of effectiveness. And once that is issued on the registration statement, that then greenlights JBS to go through the process of listing on the New York Stock Exchange. So they need this effectiveness in order to move forward with selling their stock. So the SEC doesn't have to give it and should not if they feel like the registration statement is incomplete, has misleading information, or is otherwise deficient. And so what's happening now likely is JBS just submitted, I think a month ago, another amendment. They're going to be receiving comments from SEC staff about the representations made. I would suspect many of those comments might raise some of the issues that we raise in the complaint. And then we'll see another amendment likely. And then from there, we might be able to gauge what the staff is really thinking about as far as the contents that we submitted in this complaint.
So it's sort of a cross between a legal effort and almost a political effort to try to create influence, both within the agency and outside the agency, where lots of other people are involved in this effort too.
I'll just this might be on listeners' mind, and I don't want to not address it because it's another one of those latest banger of decisions at the SCOTUS level, right? So that involves the SEC. This is the Jerkezi case, so SEC v. Jerkezi, which found that when the SEC seeks civil penalties against a defendant for securities fraud, that they have to do so in federal court because there's a right to a jury under the 7th Amendment. So I say this to say that all of this stuff is targeted to the IPO and whether or not the SEC should issue effectiveness or not. But it also alleges direct violations of securities law, right? That they have misrepresented things in violation of Rule 10b-5. And those, the SEC could independently go after JBS for those violations and seek civil penalties for violations. they're not going to do so before their ALJs. They'll have to go to federal court if they want to seek civil penalties. But they could do something else. They could enjoin these misrepresentations, right? And that could be done in an administrative process, most likely. I just want to acknowledge that there was a recent SEC SCOTUS opinion. I don't think that's going to have any impact on how the SEC reacts to this complaint or responds or what action it's going to take. And if they do decide to take a step and take enforcement action against the company for violating securities laws, there's different avenues they can take in addition to going to federal court.
But the fundamental point is that they don't have to just have the company fix their IPO. They could actually, if they really feel that there was fraud here, they could go after them for fraud. But the Supreme Court has just complicated the way in which they can do that. All right, there's a lot going on here. You guys have made it very clear, I have to say. One thing I wanted to ask you, Laura, before we go is, I noticed there were students working on this because you're, of course, at Vermont Law School, and also a number of organizations were involved. Can you just explain a little bit how the workload gets split up, either of you, in that context, and maybe just give a shout out to who else was involved, what other organizations were involved, because I know this is a joint effort. And I'm kind of interested in what role the law school played and the students were able to play.
Yes, I so appreciate this question because this was such a wonderful opportunity for students to be a part of. So, I'm sure you mentioned in the introduction, I'm the director of the Farmed Animal Advocacy Clinic at Vermont Law and Graduate School. And so this is a chance for students to engage in real world matters on behalf of real world clients. And so we're so fortunate to have the Humane Society of the United States partner with us on this and allow students to work on, the factual research, the legal research, strategizing, even press release drafting. And the students just got this incredible, unique experience to be exposed to the universe of farmed animal production and the major companies at play, right? And learn so much factually about the industry, but also learn about securities law as a tool for animal advocates. We had students like Christy Fox and Grayson Harberry do a lot of the research for this complaint. And then it was a matter of collaboration and tweaking things between the Humane Society, the Center for Biological Diversity joined on. And so it was a group effort that we were just so fortunate to be a part of.
Big shout out to Hannah at CBD.
So, Stijn, you were able to work with students as well? Was that part of what you were doing?
I didn't work with the students directly.
Okay.
Laura is the conduit. Yeah. So
that sounds great.
It was a great collaborative effort. We got a lot of information from the students, and then we sort of work with Laura, with the students, if there's questions, and sort of mold it all into what we finally put on the page. So it was a lot of people involved, great collaborative effort, and it was a really great group to be a part of. So I'm very thankful to have been a part of it.
It's very exciting. It's obviously not clear what will come of it, but I think one of the things we were able to talk about before is that so many efforts of this movement have gone on in the past. At that moment in time, it was very unclear whether anything would ever come of it, but it does seem like things are coming around and there's more attention being paid, and I'm excited about it. I want to keep on top of it. So thanks so much for joining us today on the Animal Law Podcast.
Thank you so much.
Thank you for having us.
So thank you so much for joining us on the Animal Law Podcast. We will be back next month with a new show. Thank you so much to Laura and Stijn for taking the time to tell us about this important matter. Thanks also to Vicki Beechler for her help in producing this podcast. And if you haven't already, please consider subscribing wherever you listen to podcasts, leaving us a good review on Apple Podcasts, and if you are able, making a tax-deductible donation at ourhenhouse.org/support. And thank you so much for tuning in.